The third one is the National Legislative Executive Order, which actually cancels the London Convention, and then it was served also to the Constitutional Court. The reason for that is because there were fraudulent court orders granted to enforce Her Majesty the Queen to control the Republic of South Africa by judicial officers who are corrupt. So now here we can see the fraudulent court orders which were repealed, which were actually set aside by the National Legislative Executive Order. One order granted by Constitutional Court, which was fraudulently granted by the Constitutional Court. The second order as well is the second order which was granted fraudulently by Constitutional Court. And then the third order was also granted fraudulently by Constitutional Court. And then the fourth order was granted fraudulently by Constitutional Court. The reason why we say that the Constitutional Court orders are granted fraudulently is because one example of these orders is one here of an order granted by Constitutional Court. So the order was omitted on the applicants, whereby under case number CCT 2810 of Constitutional Court, the applicant is South African Community Government and with other applicants. But now the applicants were omitted on the order, saying that this order was granted as an order of court on the 3rd of May 2010. So we complained to Senior Register, Mrs. Stender, that why this order is omitted with only one applicant when the applicants were more than one. Then she said, no, don't worry, it's not a problem. I'm going to amend the order. Then we say, if you say that you'll amend the order, are you the judge to amend such an order? She said, no, don't worry about that. You just tell me that this order has been omitted on the applicants, then I'm going to amend it. Then indeed, after complaining, because she said you must write a letter, which we didn't write a letter because we knew that she wanted to commit fraudulent activities on the order. Then, on the same day of the 7th of May 2010, by 1532, we received another order which says that it's amended order of court dated the 3rd of May 2010. So now this order is the same case number, Constitutional Court case number CCT 2810. So now, on the applicants now, there come about 4 applicants, which are now the correct applicants on the order. Now the question was, when you amend an order, you must actually send it before the judge. And the people who are applicants must be present because they are the ones who brought an issue that the order was actually omitted, it must be amended. So it must be ordered as such and be recorded that the order has been amended. And it must be provided with the transcripts. So now, according to the Criminal Procedure Act, says, in the absence of transcript, it will be a proof of fraud. Because if there are no transcripts by transcripts of recording, there must be at least transcript taken by a shorthand, whereby they've written notes, because those are 25 judges of Constitutional Court. So there's no way they can just amend an order being one single judge. There must be at least those judges who are supposed to sit and see to it that the order is amended and provided as well with the transcript. But when we asked it where the transcript, Mrs. Stender said that she was instructed by Chief Justice not to provide with such transcript as it is written in this letter. The letter says, Dear Sir, South African Community Government Union and others versus Minister for Health and others. The Chief Justice has directed me to respond as follows to your letter dated 17th February 2010. It is not the practice of this court for the Chief Justice or other justices of the court to enter into correspondence about orders issued by the court. Then when she said that we must issue a letter saying that we complain that there are no transcripts, she said we have to actually write a letter. Then we reminded her of this letter, that according to your letter, you said that the Chief Justice instructed you that you will not correspond concerning issues of orders issued by the Constitutional Court. So now, we just want to know, where are the transcript of all these orders as a proof of court proceedings at Constitutional Court? She failed to provide one. Even all the transcripts were not provided. So the next step we did, we opened the case of fraud against her. Then charges were pressed, which the police are still investigating. At the same time, we wrote a letter to the Minister of Justice and Constitutional Development asking for her to be suspended for actually issuing fraudulent court orders which are not known by the Chief Justice, whereby she even appended the names of the Chief Justice or Justice of the Court of Constitutional Court on her own orders issued by her without the knowledge of the Chief Justice. So now, the letter which we received from the Minister of Justice is this one. This letter says, Master Stephen Khoza, South African Community Government Union. Dear Master Khoza, urgent notice for the suspension of Mrs. Stender, the Senior Register of the Constitutional Court, pending the investigation of criminal charges against her. Thank you for your letter dated 1st April 2010. The Minister of Justice and Constitutional Development, Mr. Jeff Radebe, has noted the contents and has requested the Director General of the Department of Justice and Constitutional Development to attend to the matter. A further communication will be addressed to you by the National Office of our department in due course. With thanks, regards, by J.N. Labaskachen, Chief Legal Research. Date 2010-07 on the 13th. So now, this is what is happening about these fraudulent court orders, whereby we have a proof that even the Constitutional Court is involved in organized judicial crime corruption syndicate, including other orders which were granted by the High Court judges. So all these orders, all of them here, they were set aside by the National Legislative Executive orders, whereby they all are the respondents on the matter. So now they failed to respond. So the National Legislative Executive order was standing as being granted in terms of the legislature against them. The next step, as this order was granted in terms of the National Legislature of the Republic of South Africa, the next step is that the Congressional Legislative Investigation of South African Community Government Union has engaged the Gauteng Provincial Government to impeach these judges who are corrupt, and they must be removed from the bench because they failed to comply with the Legislative Executive order, and they never even answered or to defend or even to file any notice of intention to oppose until it was granted.